Good evening. Hi, we have a few people finding seats. There's some right up front. I'm Tara Ford. I am the chair this year of the Northern Kentucky Forum Board. And as people are finding their seats, I'll just address a little issue that's been on my mind today and you might have been thinking about as well. It is September 11th. Just a little personal story really quickly because we still have a few people filing in. 12 years ago, I was a graduate student at George Washington University in Washington, D.C. And got to see firsthand some very scary things and hear about very, very scary things. And while I would not change the dramatic turn that my life took as a result of that day, I definitely was changed forever by that day. And so some people have asked me today, why are you having an event today? But I can think of no better way to honor our country and those that fell, by having a conversation about a difficult topic together in a civil, respectful way, and have absolutely no fear about being here. So anyway, thank you for coming. The Northern Kentucky Forum Board exists to do this very thing, bring people together to talk about current events and public policy. We were formed by 3 organizations that are dedicated to nonpartisan community engagement and civic dialogue. Vision 2015, Legacy, the Young Professionals Organization, and Northern Kentucky University's Scripps Howard Center for Civic Engagement. We are a board of volunteers, so this would not be possible. This elite group of panelists would not be here if it were not for these volunteers working very hard. Thank you to the panel and thank you to the committee that worked on this. We appreciate the Campbell County Fiscal Court having us here tonight. And just a couple of logistics that I normally talk about. If we were to need to leave the room quickly, we do have two exits. There's an emergency exit over here, and there's the exit where you came in. If you would need to go to the restroom, it's out the door and to your right. And also, we're going to be talking about clicker questions later, and we would just ask you to please return those. You might hear a couple people mention that throughout the evening. They don't turn on anything at your house except for just these PowerPoints, and we certainly appreciate Northern Kentucky University allowing us to make use of those. So the forum has 8 to 10 events a year, just a little plug. We'd like you to turn your phone ringer off. But if you could continue to tweet to #NKYForum, and if you haven't liked us on Facebook, I would actually like you to do that right now. So, to get a few more likes in there would be great. And let's see, please join us. This is the kickoff to our fall 2013 season. We have 2 more events in September and some others coming up later this fall. So thank you again. And it's now my pleasure to introduce our moderator for this evening, Mr. John Lomax. He has been anchor at Good Morning Cincinnati for quite a while. He's lived in the Cincinnati area, mostly northern Kentucky, longer than anywhere else in his life, he says. So we are happy to call him an almost native. And in 1983, he came here to be a reporter, and he's just been here ever since. He's interested in all kinds of things that are mentioned on our program. Also, all the bios are here on your program, along with some additional information. If you didn't see it, there's resources at the back. John, thank you.
First of all, thank you for letting me be a part of the Northern Kentucky Forum. I've done this a couple of times before, and it's always informative for me because you can never be fully informed about certain issues, and to have an illustrious panel like this is certainly is wonderful. They'll examine this issue just about every which way from Sunday. Also want to thank the Campbell County Fiscal Court for making this facility available for us and for other organizations on a regular basis. This is just a wonderful facility in order to be able to come together and discuss issues like this. So I want to express my thanks to them as well. As was noted, you're going to use the clicker. Can I borrow yours just a moment so you know what we're talking about? It's a thing that looks like a small remote. You're going to use the clicker this evening, in order to answer questions that we will have for you. And those questions will be posed up here. Do not leave without them. As was noted, you cannot open your car door, you can't open your garage door, it won't work on your TV. I have tried. So be sure to leave them with someone. There'll be people at the doors that you can leave them with. They're pretty easy to use, and we're going to do a real quick test. We're going to put up some questions, and in order to, A, get a little information about you, about who you are, and in addition to give you some experience with using them. And our clicker expert, Professor Donna Spears of NKU's Chase College of Law, will operate the system. And Donna, let's see, you want to, she put it up, and you can see there are 3 different locations here where these questions are up. And let's go ahead and answer this. I am a resident of A, Boone County, B, Campbell County, C, Kenton County, D, some other community in northern Kentucky, E, Cincinnati, or F, I'm from outside the region. And those letters should correspond with your clicker. Yeah, so, see how that works? So go ahead and tell us where you're a resident. Do that right now. Has everybody had a chance? Any questions about it? Go? She said don't worry about go. Just pass go. All right, just hit that. And you see, there's a bar graph that comes up. When she assembles the information, you can see 58% of the people are from Campbell County. All right? Let's try another one. You want to try another one? Yeah, I say we try another one. Let's put up the next slide there. Do you have a library card? A for yes, B for no, or C, I did, but it expired. Okay, go ahead and tell us A, B, or C. And we're not the NSA, so we don't know who is saying what. All right?
And these are anonymous.
It's all anonymous. And there you go. 90% of you say you do have a library card. But it's interesting, the 6% of you have let one expire. That's more than people who don't have one. I don't know what that says, but it says something. All right. And our third and final preliminary question is this one. I last visited the public library, A, within the past month, B, within the last 6 months, C, within the last year, D, within the past 2 years, E, more than 2 years ago, or F, never. I've never been to the library. So, answer that one for us. And there you go. 77% of you have been to the library within the past month. 0% of you who voted say that you have never. You know, so that's good. So everyone in here has at least been in the library at some point. That's excellent. We also have question cards, which we have distributed. Toward the end of this discussion, we will ask the panel to field your questions. These wonderful people right here, who I will introduce to you in just a little bit. When you have finished filling out the card with your question on it, hold it up and one of the volunteers here will come by and they will get it. Now, I will actually read your question. We have people here who will actually pick the question, and it's not to edit the tone of the questions that are asked of the panel. Rather, it's to keep the same question from being asked 10 times. So they will sort of be docents over the process and pick out. If you would like for me to recognize who it is that asked the question, put your name on it, and I will ask you to stand so that I can acknowledge the person who asked the question when we pose it to the panel. But if you don't want that, don't put your name on the card, and that's perfectly fine. It will not matter whether you put your name on the card or not as to whether your card is selected to be posed as a question to our panel here this evening. So, question cards. Here's our flow this evening, how we hope this will go. We're going to try to keep things on time. We're going to take a few minutes, about 10 minutes or so from the start. We're going to talk to a tax expert who is on the panel. I'll introduce him to you in just a moment. And then we're going to spend a little less than an hour of the discussion with the panel themselves, during which we're going to intersperse clicker questions from time to time, and we'll pause to look at those results and respond to those. And then for the last 15 minutes or so, or as time allows, we will ask the panel your questions, which you put on the question card. And once again, if you don't want to be acknowledged, don't put your name on the card. It will not affect whether your card is selected or not for the question. So, and finally, as Tara noted, I can't reiterate enough, let's think of this as a discussion. I know that this has been a passionate issue for many of you. But tonight we want some stability and insight. We want to generate some light and not so much heat. And we hope that you leave this event better informed and not angry with someone. So, all right. We can hope. I heard that smirk over here somewhere. But I think we can do that because we're all people of good intentions. All right, then. Let's see. I think now we're going to ask a question. Let me introduce the panelists to you first, okay? First of all, we have Kim Fender. Kim Fender, raise your hand. Kim Fender has served as the Eva Jane Romaine Combe Director of the Public Library of Cincinnati and Hamilton County since 1999. Ms. Fender received her bachelor's degree in anthropology from Northern Kentucky University and her MLS degree from the University of Kentucky. She was awarded a graduate internship at the Kentucky Department for Libraries and Archives and accepted a position as a reference librarian at the Boone County Public Library once she received her MLS degree. Ms. Fender is also a member of the Campbell County Board of Education. Andrew Hartley. Mr. Hartley? Andrew Hartley is the city attorney for Georgetown, Kentucky. Prior to coming to Georgetown, Mr. Hartley served as a staff attorney for the Department of Local Government in Frankfort, where he advised cities, counties, and special districts on various issues. And during his tenure at DLG, Mr. Hartley often dealt with ad valorem tax levies, House Bill 44 limitations, the compensating tax rate, and its evil twin, the substitute rate, and the role of fiscal courts in setting, influencing, and accepting special district tax rates. He successfully defended a challenge to the department's method of calculating the compensating tax rate. Mr. Hartley also helped the Auditor of Public Accounts draft the Special District Accountability and Transparency Act, also known as House Bill 1, which was enacted into legislation earlier this year. Erik Hermes. Mr. Hermes is an active Campbell County resident and business owner. He's been married to his wife, Melissa, for 22 years. Erik is a father of 3 daughters and 1 son, and is actively involved in his community and has recently completed a 3-year term on parish council at St. Philip Church. Erik also serves as the Campbell County 4-H shooting sports rifle coach and volunteers to help with concessions at Campbell County High School football games. Erik Hermes. Jeff Mando. Jeff Mando, at the end there, of Adams, Stepner, Wolterman, and Dusing in Covington is the attorney representing the Campbell County Public Library and the current lawsuit challenging the library's tax support. A veteran civil trial lawyer, Mando has extensive experience representing cities and counties, elected officials, and public employees in state and federal court. Active in community and charitable causes, Mando has served as a member of the Kentucky Board of Education as well as an adjunct professor at Thomas More College. He's also served as a special justice on the Kentucky Supreme Court, and he resides in Crescent Springs with his family. Barbara Stripling is president of the American Library Association, holds the position of assistant professor of practice at Syracuse University in Syracuse, New York. Previously, she served 7 years as the Director of School Library Services for the New York City Department of Education and as President from 1996 to 1997 of the American Association of School Librarians. Stripling received a BA in Speech and Drama from Stanford University, an MA in Communication and Theater from the University of Colorado, and an MED in Instructional Resources from the University of Arkansas. Also has an EDS in Educational Administration from the University of Arkansas, and a doctorate of professional studies, information management from Syracuse. Brandon Voelker. Brandon Voelker, practicing attorney since 1999, received his Juris Doctorate from the University of Kentucky. With vast professional experience representing both plaintiffs and defendants, Voelker's concentration is on litigation. Current affiliations include the Northern Kentucky and Kentucky Bar Associations, as well as the University of Kentucky Alumni Association and the Northern Kentucky Chamber of Commerce. And last but certainly not least, Mr. Jim Waters. Jim Waters is president of the Bluegrass Institute for Public Policy Solutions, Kentucky's first and only free market think tank. He previously served as its vice president of communications, and Jim uses his significant media experience as a reporter, editor, and broadcaster at newspapers and radio stations in Kentucky, Indiana, and Ohio to grow the Institute's influence in Frankfort and its impact statewide. Quoted often in the state's major newspapers, he writes the Bluegrass Beacon, a weekly newspaper column that appears in publications statewide. Jim frequently appears as a guest on talk radio shows statewide and frequently fills in as a guest host for WLAP's Matt Walsh in Lexington. Ladies and gentlemen, this is your panel. let me just add this, so I don't have near enough to do after listening to what these people have accomplished in their lives. So, all right, we're going to start off with a clicker question. We want to make sure you still know what you're doing here. So, with which statement do you most agree? Public libraries require tax support, and A, the current funding model works. B, I think public libraries require tax support, but the current funding model is flawed. Or C, I think public libraries require tax support, but I am not well informed on the current funding model for public libraries. Yes, sir.
Can you clarify which of the current funding models you're talking about? House Bill 44, the one the judge ruled illegal, or KRS 173790, the one that it's supposed to be under?
Well, I'm going to make an executive decision. All right. Let's say that the model that the Campbell County judge declared was not the proper one. Let's say that. Okay. Is that fair? Is that fair with everybody? We can go with that. All right. The current the B selection. It says well, all three refer to current funding model. Let's assume, because it's still under appeal, that the current model is the one that the Campbell County judge said was not proper.
That's not
Which one is what? How about?
Well, which one is being used right now by the library? Is either one being used right now?
House Bill 44.
Well, House Bill 44. Let's say it's House Bill 44, which is the one the judge said should be used. Let's use it. No, that's 179.
Maybe this Kentucky Department of Library and Archives has instructed all 80 libraries across the state formed by petition to continue to use House Bill 44.
Which is the one that the judge said should not be used, right?
That's correct. Right. That's what they are continuing to advise libraries to utilize at the current time, despite knowledge of those orders.
All right, so House Bill 44 is the one we will call the current funding model. And you can say whether you believe it is flawed or not. You have the option there. If you believe House Bill 44, the one that the Campbell County judge decided was not the correct model for taxation, is it working? Is House Bill 44 working? Is it flawed? Is it you're not well informed on the current funding model for public libraries? A, B, or C? House Bill 44. All right, polling is closed now, and 51% of you say that, who are here, say that House Bill 44 works, is a current model and it works. 24% of you say that it's flawed, and 24% say that you're not well informed enough. So I would consider myself one of those 24%, and we're going to let an expert look at these results, tell us about Kentucky property tax laws, because I know the ad valorem taxes are really important in this discussion, especially for library districts throughout the state. And I believe that some of these provisions may also apply to cities and counties as well. So Andrew Hartley, the hot potato is yours.
All right, well, thank you to the forum for having me, I guess. Thank you. It always makes me nervous when anyone holds me out as an expert on anything, especially on taxes. I was just talking to Mr. Waters here briefly. The word in your question that makes me the most nervous is working, because I don't really know how you define working. Certainly it is providing funding to the libraries. You know, the House Bill 44 system was established in 1978 as a way to keep real and personal property tax rates tied to property values, to the increase in new property rather than to the increase in the value of the dollar, inflation. But what it did was to set some rigorous guidelines. Does anyone else think the microphone is cutting in and out on me? Okay, maybe if I hold the button down. I'll try to speak up. The House Bill 44 puts in certain limitations to sort of keep the real property and personal property tax rates of cities, counties, and taxing districts in check, if you will, and it's a system of really of public participation, and also, depending on how high they change the tax rates to public override. And so for the past 35, 40 years, library districts have been operating under the principle that as long as they follow the House Bill 44 guidelines, whatever tax rates that they put in place would be deemed lawful. So as many of you know, over the past 40 years, it has resulted in quite a few libraries going from, say, 3 cents on the 100 rate to a 6 cents on the 100 rate. So again, I go back to the question of working. Yes, it is providing funding to these libraries, and it seems to me that it's providing increasing funding. What I think is not working is the system doesn't really recognize the needs of a community to be flexible in terms of their tax rate. And there's a lot of confusion as to what the House Bill 44 limitations mean and who they apply to, and I can only hope that regardless of the outcome of this case, that we get some input from the legislature going forward as to how House Bill 44 is going to affect all taxing districts, all counties and cities. That's
All right, well, it's a little background on what has happened so far, and possibly what is at the source of some of the controversy as it applies to these libraries created by petition. So we're going to have another clicker question in order to set up the next part of our discussion. Which of the following statements best describes your point of view? A, the Tea Party is on target challenging the funding model for public libraries. B, the Tea Party's challenge of the funding model for public libraries is without foundation. C, the law should be changed legislatively rather than by a court case. D, I need to learn more because I am not well informed about this case. Tell us what you think. All right, here we go. And you can see that 21% of you agree with the premise there in A, 51% B, 17% C, and D, 11%. And now, Erik Hermes is the plaintiff in the case. Brandon is his attorney. Erik, as a plaintiff in the case, challenging how the taxes are being collected. Could you and Brandon take a couple of minutes? And just so you know, in an effort to keep this on time, we are going to give certain segments a time limit. In this case, it's 2 minutes. And in 1 minute and 45 seconds, I will acknowledge that. And then when the 2 minutes is up, I'll say stop, in order to try to keep it moving and to try to keep it as fair as possible. So let me pose that again. Erik and Brandon, if you could take a couple of minutes to explain why you sued and what outcome you want to achieve. Are you opposed to public libraries in general, or just the way they're funded?
The reason for the lawsuit was to establish the correct method for raising the library tax rate. I had taken it upon myself on several occasions to address the library board. In fact, one of the meetings was with Brandon, that also attended, about that it was being done incorrectly. This was long before a lawsuit was in place. And we could not get satisfaction, couldn't get attention from the library board, because their basic feedback was they are doing it correctly. And so the basis was basically the only way we're going to be able to get a clear answer was to get a judge's decision on what is the proper way for the taxes to be raised or changed through HB 44 or through KRS 173790.
To Mr. Womack's question, I think one of the things that Mr. Hermes and the other plaintiffs, no one's opposed to a library. This isn't really a case about whether or not libraries are good or bad. I think we all grew up with libraries. We all went to school. We all probably can still name our elementary librarian. The issue was one of taxes and following the law. House Bill 44 was enacted in 1979, but the petition libraries Mr. Mando referred to were kind of a special creature of statute. Those were enacted, there's I think 77 in the state. So in Campbell County, for example, in 1978, everybody lived in Campbell County petitioned the fiscal court and said, we want to have a library, and I agree that I'm going to give you 3 cents of every $100 because I want a library. And the statute that was written said, when it wants to increase or decrease, you got to go back to the people. And so what happened was when House Bill 44 was passed, instead of following that statute, which would allow a library to seek petition and raise the tax to whatever rate they want, as long as they take it to the people, instead they start following House Bill 44. And both judges in Kenton and Campbell, because the library's argument was, well, House Bill 44 repealed by implication that old statute. Well, in 1984, House Bill 36, the legislature basically at that time did away with the ability to create a library by petition or by ballot, which is what they have in Boone County. And so what they did was they said, but these are a special needs term animal, because these are something the people came for. These weren't an act of government. These were an act of the people to create these libraries. So they said, but those libraries formed prior to July 13th, 1984, the same rules apply. Now, why KDLA, when I say KDLA, I'm referring to the Kentucky Department of Library and Archives, why they advised all libraries to follow House Bill 44, I can't answer that question. I think I was 12 years old at the time. The issue that you have is there's about 5 different ways to form a library in Kentucky. But the one thing that both judges pointed out was there was a unique statutory construction that applied to libraries. And that the biggest thing was that they're controlled by the people. So the case isn't about whether libraries are good or bad. It's about whether or not the people have a say in the size and scope of their libraries. And judging by the response, I would venture to say 51% of people in this room are probably in agreement that the library rate should be doubled. I think that if a petition came to your house and you said, are you in favor of doubling the rate? I have a feeling 51% of people in this room would say yes. I also have a feeling that probably 21% of the people in the room, if they got a petition that said, should the rate be lower, would probably say, yes, it should be lower. As we talked about in the open with 9/11 and the idea for civil discussion, that's really all this issue is about, is civil discussion. The people decide the scope. It's not about whether libraries are good or bad. It's about that the residents of Campbell and Kenton get to pick and choose what their library is about.
All right, Mr. Voelker, thank you. Mr. Hermes, thank you. Mr. Mando, you addressed this question a little bit in the explanation of what we consider the current funding formula right now, but you're the attorney defending the Campbell County Library. Tell us where your challenge stands right now and why you think that Erik and Brandon are legally wrong.
Right now, the case is in the Court of Appeals. Motions filed for the Court of Appeals to rule on some preliminary motions in the case. But we believe that the library has been following the law, as well as 79 other libraries across the state, because House Bill 44, which sets the tax rate for all taxing districts, was adopted in 1979, more than 15 years after the statute that set the specific rate in 173-790 back in 1964. And so when the General Assembly in 1979 passed this comprehensive statewide legislation for taxes, it said all taxing districts shall use the compensating rate. The library is a taxing district under Kentucky law. As a result, the Kentucky Department of Library and Archives, which is the state agency charged with overseeing libraries across the state, provided guidance and instruction to all of the libraries across the state saying, you shall comply with House Bill 44 and use the compensating rate. So libraries began to follow that instruction, and for 34 years did so without any objection, without any question, and without any lawsuit. If the true purpose of a statute is to reflect the intent of the General Assembly, which ideally reflects the will of the people, I think it's certainly reflective that no one from the General Assembly, knowing how libraries were implementing and using the tax rate, objected and said to any of the library districts, hey, you're doing this wrong. And that went on for over 34 years. There's also Attorney General's opinions that say that the libraries, in following House Bill 44, have been following the law. That's our position.
And it's still under challenge right now.
It is under challenge in the Court of Appeals, and I envision that it will probably end up in the Supreme Court, where by agreement, Mr. Voelker and I tried to take it so that we could expedite this issue, bring clarity and finality to the litigation. Unfortunately, the Supreme Court said, no, you've got to go to the Court of Appeals first.
Thank you, Mr. Mando. Erik, I want to go back to you for just a moment. The lawsuit basically is about taxes and oversight of a public institution. I know that you said that this is not about the library's existence, but rather following the law and its funding. But some of the people who have attached themselves to your cause have been critical of the libraries themselves, saying that they're overbuilt. Some have questioned whether public libraries are even still valid in the digital age. Talk about your feelings about challenging what libraries consider their lifeline right now, and that is their funding. What your personal feelings are about that.
I'm sorry.
Well,
Not understanding.
Right. There are some people, even though you have not said, and matter of fact, you made a point of saying this is not about the existence of libraries, that it is about following the law, when you perceive to be the law and the funding of the libraries. Nonetheless, it does threaten their lifeline. This lawsuit does threaten their lifeline, which is their funding. And there could be significant ramifications depending on how this turns out. What would be your feelings about that? About whether you want the libraries to exist or not, that you may significantly damage them?
There's no question that I want to see the libraries exist. I have a library card. I use it on a regular basis. All good institutions have limits. Too much of a good thing, is bad. And there should be funding limits set and the rules set in advance. And just to give a for instance, as far as whether this is hurting the libraries or not, actually this lawsuit was filed over a year and a half ago. There's been a judge's determination on this particular case about 6 months ago. Now take a step back, and what we see, we still have the same number of libraries we had before the lawsuit was filed, the same number of hours, the same basic services, same programs. The lawsuit is not hurting any of the libraries. And again, I just want to state the purpose is establishing what is the correct method, because there's big confusion. What is the correct method? Is it HB 44 or KRS 173-790? And at this point, 2 judges have agreed with us that it is KRS 173-790.
All right. Would anyone on the panel, Mr. Mando, anyone else want to respond to what Erik said?
I would just like to say that the restriction, I don't know the current Kentucky case, whether there's a restriction based on the amount of time that everybody is spending fighting off the lawsuit, which I assume there is a great implication in terms of services. But really what we need to think about libraries is the future of libraries and the building up of the future, and the possibilities are almost limitless. Your libraries right now in Kentucky, as across the country, have so many potentials for the community in terms of building maker spaces, in terms of finding a balance of electronic resources and print resources, in terms of opening up a whole lifelong learning avenue for every member of the community, in terms of building early learning. And those are the kinds of things that we need to focus on. It cannot be done without money. It can't even be done if we're spending time on fending off a lawsuit to preserve money. We need to actually be building. This is a time where libraries are moving toward the future, and we're making those plans. They're transforming all across the country. It's a time of advancement, not a time of retrenchment.
Mr. Stripling, while you have the microphone, let me ask you a quick question, because you have a national perspective on this. Do you see challenges like this in other parts of the country?
No, I have not seen a challenge like this.
So this is unique.
But certainly funding is an issue across the country. With the recession, we have found that funding is restricted in libraries, and it's interesting because we've also found a huge upswing in the use of libraries across the country. And when times get tight, economic times get tight for our community, we found so many more people are visiting the library to build their employment skills, to find a job, to have access to the internet, to have access to computers, to have access to books for their kids. So it's an interesting dynamic, but I haven't seen this kind of a lawsuit.
All right, we want to bring a different perspective. And I'd like to bring Mr. Waters into the conversation here. Jim, the Bluegrass Institute, your institute, is a think tank for conservative issues. And you
free
have
market.
Free market. Okay. You have concerns, though, I understand, about the reach of government. Would that be fair? Yeah, about the reach of government and the cost of government, certainly. Talk to us about that concern in broad terms. By that I mean, where would the line start and stop as to what government should do? And how do you see this challenge of taxes to support libraries fitting into a broader debate about the government's role?
It's a great question, and thank you, by the way, for having us here tonight. This is great, and one of the things at the Bluegrass Institute, we want to encourage is citizen involvement and engagement and these kinds of discussions. So whatever side you're on or whatever view, we appreciate this, and I appreciate the other panelists too. I probably spend more time in the Carnegie Library in Wabash, Indiana, growing up than I did at home. I love the chess games they had there, and I played my first electronic chess game that night. But so I'm a big fan of libraries. I'm a homeschooling parent. Our kids enjoy the programs that our local libraries have for children, and so I know Ms. Stripling would love to correlate a call for responsibility and accountability to sort of paint that as being we want to retreat and we want to go back and we want to cut libraries and we don't want to have libraries. And I'm not going to sit and allow that. That's not my view. My view is that libraries are great, but like any service that's provided, I think there needs to be accountability and transparency in the process. And I don't think it's so much about what works as it is about what's legal and what's constitutional. This country was founded on the principle that we would not have taxation without representation. And I think that's a very important principle to protect and defend, even whether we're talking about it at the local level or a state level or a national level. So that, Kentucky families are having to live within their means, Kentucky businesses. They only have so much money, and government must live within its means. A government entity must live within its means. So, but that does not mean that we're opposed to libraries. What that means is, if you want, for example, a new library branch, then maybe you might have to make difficult, tough decisions about redirecting resources. Maybe you don't have so many videos. I was really surprised at how many, there's like 300,000 movies here, and we have Netflix, we have the Red Box, we have plenty of options there. So maybe you take some of that funding that you're purchasing movies for and that you're fighting lawsuits, and you put that toward maybe another branch or or expanding the branch. Another way is to have philanthropic help. In Bowling Green, we're expanding one of our libraries there, and it's being done totally by the private sector because they love libraries. So My grandfather used to say there's more than one way to skin a cat, and I think there's really more than one way, maybe even better ways to grow our libraries and expand them where they're really wanted, where expansion is really wanted.
All right, and you brought up the issue of the kinds of things that you find in libraries, whether hard decisions have to be made about whether you have 300,000 videos and that sort of thing. Kip Fender is really in a unique position here. You run our region's largest library, and that's the Hamilton County Cincinnati Public Library. But you also serve on the Campbell County Board of Education. So you got a foot on both sides of the river here. So what about the role of public libraries today? We do have digital books, we have access to the internet, and schools have libraries as well. Do we need to fund libraries as we once did, or do we have to do as Ms. Fender said?
Well,
Mr. Waters, I'm sorry.
That's okay, Mr. Fender's here too now.
Yeah, okay.
It's not really. Obviously, I would not have devoted my entire career to working in libraries if I didn't feel that they added something important to our communities. Public libraries are different from school libraries. Obviously, as adults, we would not want to be restricted to only the materials found in a school library. And there's always the question of how much content should you have in different formats, those kinds of things. But those are decisions that professional librarians make because there are public libraries, and we're here to serve the needs of the public. And so if we have demand for fiction of all types, of movies, music, and electronic formats, then we have an obligation as a public library to make those available to our public. But I think the other thing that gets missed in those conversations is, yes, we do have Netflix and things, but not everyone can pay for Netflix. That's both requires a subscription to Netflix and home internet access. And that adds up to a pretty substantial monthly cost for many people. And so providing that for those who cannot always afford to pay for those extras is a service that libraries have done for many, many years. And it's still critically important, especially, as Dr. Stripling pointed out, in times of economic distress when people are looking for ways to save money. We do see use of libraries increase dramatically.
All right, we want to use this opportunity to maybe ask another set of questions of the audience along the same topic. And here it is. In this digital age, public libraries are A, as important as they ever were, B, more important than ever, C, less important than in the past, or D, libraries are obsolete. What do you think? Don't let this come to work.
It's okay.
All right, and here we go. B, 58%. Our audience, 58% of our audience believes that libraries are more important than ever. 2% of you believe that libraries are obsolete. You can see the numbers there for themselves. In listening to the panel, there's some very subtle differences about what it seems to me that you want from your library, but I haven't heard a single person here say that libraries are obsolete, that libraries are unnecessary. Funding mechanisms and those kind of things. It is just so complicated to try to figure this out. You guys, Mr. Mando, Mr. Voelker, you've defended this, your relative position in court. Are there simple ways to explain to people like me what the legal issues are? Is it that there are two funding mechanisms? I'll tell you what's confusing me. Is that there are two funding mechanisms possible, but the judge didn't find them incompatible. And I don't understand that. If either one works or the other one works, if one works, then the other one should. So maybe, not being an attorney, maybe you can help us to understand what the legalities are about why these two funding mechanisms contrast. You want to go first?
Sure.
Okay.
The issue is, Mr. Jones, you're correct. There's two separate statutes, and it pretty much is, Jeff and I agree with it. Whether House Bill 44 applies for KRS 173-790. I mean, I think Jeff and I agree with that. That's really a fundamental issue before the court. The reason that there is a conflict is the House Bill 44, you won't find the word library mentioned in all the pages or anything else. The conflict arises because KRS 173-790 is specific to libraries. And both of the judges ruled that under our general rules of statutory construction, if there's two potential statutes in play, the more specific governs over the more vague one. So therefore, the specific one, and as I mentioned earlier, even spelling out a date and saying that, hey, if you were formed prior to July 13th, 1984, KRS 173-790 applies. That's what the judges said, because when there's a conflict, a judge has to determine which statute applies. The other issue is, at the time in 1980, I think 83, 84, our current governor, Steve Beshear, was actually the Attorney General, and his office authored, I think, two or three opinions after House Bill 44 was enacted that both said KRS 173.790 governs the tax rate of libraries. And I think Judge Ward referenced that in her holding. And then Judge Summey in her holding in Kenton actually went through that 1984 amendment where the legislature went in and struck through certain language, like the ability to create a library by ballot or petition, and preserve the right of the people to decide. So, I mean, it's not a question on here, but one of the questions I would like to know is, because everybody's saying whether a library, this could be doom and gloom for a library, this could cause drastic cuts. Is there anyone here that believes that, does anyone know that if the current judge orders are upheld, does anyone in this room know that if you're presented with a petition you sign to make the rate in Campbell County 0.77, or if somebody came and asked you to have the rate of double that? Is there anybody in the room, how many people in the room know that if you sign a petition and over 51% of the voters in Campbell County also sign a petition, that becomes the rate? Does anybody in this room know that is the ability to increase the tax rate? And so one of the issues is, it's really not a matter of, we're all going to have different views of whether Netflix should exist or the library should have volumes of rental movies. I can't tell you, I'm not a librarian. But what I do know is, I guarantee if somebody like Ms. Stripling came to my house and asked me to sign a petition with the passion and the values that she could show that it shows to a community, I guarantee you, I'd be giving it a hard thought on whether or not I want to sign that petition. And I very well might sign it. On the other hand, if somebody comes and shows me, and maybe I do, I'm concerned that in this county a Blockbuster went out of business. And I'm concerned that, Netflix, why should I fund for people to have free movies and stuff? I might choose not to sign it. But the facts are, it's a democracy, it's a choice. And the lawsuit is really not about that if there's going to be a winner and a loser. If the current judgments are affirmed and KRS 173.790 applies, all it means is, I would hope everybody in this room, whether they're for or against where the tax rate should be, you should go out and talk to your neighbors, and there should be a petition drive, one way or another. But it's not an issue, and unfortunately the courts have to get involved because no one was applying the law. But there is relief, whether you agree or disagree with the language. It's not final.
Now, Mr. Mando, do you have a response?
Sure. I agree with Mr. Voelker that to answer your question, ultimately the question of the court is which statute governs. 173-790 adopted in 1964, or House Bill 44 that was adopted by the General Assembly in 1979. It really doesn't get any more simple than that. However, the impact of what will happen if those court orders are affirmed is something that needs to be talked about. Because what that means is that Campbell County's rate, for example, currently at 7.7, would go back to 3 cents. The library's annual funding would go from 4.6 million to 1.6 million, like that. That will have a dramatic, drastic impact on services that the library performs for the community. I know if you lost 50% of your income, you couldn't continue to provide the same services and do the same things that you do now. So when you say, we talk about this and we agree that it comes down to the statute which one governs, we do need to have a discussion about impact of what happens at the end of the day. because as a practical matter, that's what Campbell County's facing, that's what Kenton County's facing, that's what 78 other libraries across the state are facing. And some of those libraries are in small counties where that is one of the most important cultural centers in those communities. And they don't have some of the other funding sources that, and maybe the resources that we have up here in Northern Kentucky. The other thing that I wanted to address is, yes, if Mr. Voelker and the plaintiffs prevail in the case, if there is a provision that you could go out by petition in order to secure an increase in the tax rate. However, that statute also says that we would have to get 51% of the voters who voted in the last general election, and that we would have to secure those signatures in 90 days or the petition fails. Now, I'm all about people and giving them the right to vote and the right to speak, but the way that statute's worded and the way it's framed in our society today is a practical impossibility to try and go out and get 20,000 signatures, have them verified, and all done within 90 days. I think we all know that that was the problem that was experienced with the Planning Commission when they tried to comply with a similar statute over in Kenton County.
Yes, sir. Go ahead.
I'd like to try to broaden your question a little bit to encompass other districts as well, not just library districts, and play off your question of what is the legal issue. You know, the world of taxing districts is confusing. There's 100 years worth of legislation governing these taxing districts. There are almost 25 different types of taxing districts. There are 4 different ways you can derive your taxing authority. There are those that are completely autonomous with the power to levy, completely independent of other bodies. There are those that are only partially autonomous with the power to levy a tax subject to some approval. There are those that are dependent on the creators. If they're created by a fiscal court or a city, they have to come back to them to get their tax rate. And there are those that are voter dependent. And I would even argue there's a 5th category where we're just not sure. The law's been changed so many times, and the authority to tax has sort of disappeared. Agricultural extension districts tax in every single county in the state, but I defy any of you to find anywhere in the law where it says they have the authority to tax. But there are even districts that can be created themselves, like libraries, in a multitude of ways. For example, health districts, if they were created prior to 1984, they're autonomous. If they're created after 1984, they're only partially autonomous. The problem that I see is a lot of these districts were created so long ago. Some of them, 80, 85 years. There are some fire districts that are around for 100 years. Not all of them remember how they were created. I know you all might find that really shocking, but over time, documentation disappears. People, there's turnover, there's new board members, and the next thing you know, nobody knows exactly what kind of district they are and what kind of taxing authority they have, and they just keep going on about their business. And then all of a sudden you get a change in the law, like in House Bill 44, and everybody goes, well, surely that applies to us. Surely that is the law that governs us. And the real problem is that the legislature needs to take about 1,000 statutes and consolidate them and fix them. And that is a monumental task.
Mr. Walters, he's ready to go.
Well, that's precisely why you have the law, is because over time, those things are forgotten, the original intent. So I would say, you have a law. I think that that's a fair assessment, that the legislature needs to work on this, but in the meantime, you can't just ignore the law. I mean, we have to follow the law, change the process, but don't ignore the law. And plus, I guess I have to ask this, and this might be an overly simple question, and I know government types like to keep things a little complicated, but for me, this issue of expanding the library was put on the ballot, was it not, here? And was it not defeated here? So we're not talking here just about difficulty in securing signatures, which it is difficult, but we're talking here about the courts have said no to this, and the people have said no. So I don't think the people are saying they don't want libraries. I think they're saying that we're spending enough as it is, and we want this to be constrained to the aspects of the law as it currently is understood. And I think the specific statute that applies to libraries, the judges have recognized that law.
Eric? I just wanted to address something real quick, what Mr. Mando said about the possibility of getting petitions signed. When specifically the Campbell County library system was started in 1978, 5 petitioned. So those petitions were required in 1978. So it's no harder now or no easier now than it was back then. It's been done. Well, and I take that back. It is a little easier now because now the library has 3 well-attended library branches. In fact, the library publishes that they have over 600,000 people that come to those 3 library branches on an annual basis. So if you cut that down to, well, how many people are in a 3-month period, which is the period that you would have the petition drive, it's more than 150,000 people, and the number of petitions that would be required would be about 21,000. So I don't see it may be difficult, but it's certainly possible to get 21,000 signed petitions from 150,000 people that attend the library. And those are just the people that are walking in. There are other drives that can be done to achieve even more petitions. So I think it is very doable. And the other advantage of 173790 is that there is no limit as far as how much can be increased. In House Bill 44, which the library has been using, the limit is 4%. And KRS 173790, there's no limit. The library board can determine a rate, and provided they get the signed petitions, that rate now becomes valid.
Let me ask another question, and it's not been broached here. At least I don't think it has. If I understand, some people who represent libraries, they're just worried, very worried, that this will mean a rebate of taxes that have been paid since 1984 or whenever the rate went up. Or they were able to collect taxes based on the most recent House Bill 44. Is that what you want? Do you want that to be rebated?
Based on the way Judge Ward, which is the Campbell County case, ruled, the only people that would be eligible for a rebate would be the 3 plaintiffs in the case. So we're only talking a couple of $100. So we're not talking about it, unless I'm wrong, Brandon.
No, Judge Summey ruled that you would have to apply for a refund individually. So yes, I mean, people who would want a refund could definitely apply. I think one of the things that gets kicked around is, trying to come up with a compromise in this. But the library has concerns about a compromise being binding on future people or somebody else wants to make this an issue. But yes, I mean, there could be refunds because if government did pass a tax that wasn't legal, and if the 2 judges' orders hold up, then yes, they did overtax. One thing though, on the House Bill 44 issue, I know he won't mind mentioning his name, but Shannon Denniston is here, who's a resident of Montgomery County. And on one hand, we sit here and talk like House Bill 44 is what is being used to give libraries more and more money. But I'm going to give you an illustrative fact of where the use of House Bill 44 actually financially harmed the Montgomery County Library. The Montgomery County Library was, I believe, formed in 1980, Shannon?
Yeah,
1980. They have, again, the residents of Montgomery County said, we want 3 cents. We'll give you 3 cents. Well, when the tax rate got ready to be set, the library board was then advised that they had to go by House Bill 44, and at one point the rate was down to 1.5%. So on one hand, tonight's forum seems to be more about that House Bill 44, the people that are seen here as pro-library, trumps KRS 173790. But no, for about 3 to 4 years in Montgomery County, House Bill 44 was actually utilized, if you agree with Judge Ward and Judge Summey's rulings, to actually circumvent the will of the people of Montgomery County to, in fact, for a 3 to 4 year period, lower their tax rate. And that's where, again, back to what the plaintiffs are trying to accomplish. It's a simple fix. It's a simple solution. the people decide if you live in a ballot or a petition library district. You just go and take it. Now, I think people have to agree to disagree on whether or not you can accomplish getting 51% to sign a petition or not. And it could be that there might be 51% who would petition to lower the rate. Again, but that's something that I don't think anyone up here can say what would go through the minds of every voter in Campbell or Canton County.
Mr. Hartley noted how many different taxing possibilities there are for many different municipalities and governmental districts and that sort of thing are in the Commonwealth. I know that the Cincinnati, Hamilton County Public Library had some funding issues of its own some time ago. Talk about when there is there's a level of being unsure about level of funding, how that affects what you do, how you plan.
Well, you're correct. Starting in about 2001, our state funding, which was our primary source of funding for many libraries in Ohio, began to be reduced, partly because of the economy, partly because of legislative action. And at the end of the day, it ended up being cut by about 30%. But the uncertainties of funding certainly leave you with hard choices to make. You can't do any kind of long-term planning. You know, if I were working at Campbell County Library right now, I'd be very reluctant to fill vacant positions or make any kinds of long-term funding commitments because I would be unsure of having that funding. And what we did in that case, because libraries in Ohio are funded completely differently than in Kentucky, is sought another source of revenue, which was a tax-voted levy. So, and that did succeed in 2009.
All right, Ms. Stripling, you have a national view, as we've noted once before. Libraries, how do they handle funding issues in other parts of the country?
It's a wide gamut of ways that libraries are funded. I've seen everything from local control totally, a tax levy at a local area, to state funded, to half state, half local, to it's a huge gamut.
Yeah, I guess because there is no real standard way of handling libraries anywhere in the country, it appears. What's the end game here? Is this going to be settled by court, or is it settled legislatively, or does it have to run its course legally and then the legislature has to address it? Mr. Mando, what do you think? Look at your crystal ball, folks.
Right now, it looks like it's going to be up to a court to decide first which statute governs the funding for libraries across the state. I think ultimately this will end up as an issue before the General Assembly. In fact, I would encourage the General Assembly to provide the clarity and stability on which statute should govern, which funding mechanism libraries should use, so we can end the litigation, stop paying me, stop paying Brandon, and tell us. Just tell us what it's going to be. And that begs the question of no other taxing district has to. They follow House Bill 44. They don't have to go to the people and get the petitions. Why should libraries be treated differently? That's more of a question for the General Assembly in terms of how they secure their funding. So that's where I see it going.
What about you, Mr. Voelker? You think you got to go what Mr. Mando says?
No, I agree with Jeff. Yes, it's something that, for better or worse, right now it's going to be decided by the courts. I don't think the legislature is probably going to touch the issue because, nothing gets through Congress, nothing gets through the General Assembly. I mean, our government operates in a logjam these days. I do think that and Eric and I were talking before this, and we've always talked about this, I think that what you will find is I think a lot of people's kind of, where they're upset with House Bill 44, and I think as Mr. Hartley points out, House Bill 44 is a lightning rod issue, the compensating tax rate and all that. I think that most people that I know on this issue, fundamentally, whether or not it's a petition or not, I think it's a fundamental issue of whether or not unelected persons should have the power to tax someone. I mean, my personal views are that all these taxing districts should probably have to have the taxes either voted up or down by the persons we elect to the Campbell County Fiscal Court. I believe all of them are here tonight. Because if I'm not happy with what they decide, I can speak out when I go to the ballot box, and then that preserves the issue of the 51% petitions needed. The other alternative I think is a viable option is Miss Fender's. In Ohio, they always have tax levies. So in Ohio, they operate more on you go to the people and ask for a tax levy. I think either one of those models are fine, and if there's going to be a legislative change, that's where you need to go, because that keeps the control with the people who are paying the tax versus unelected persons. But I think that's your two best models, and I think a model along those lines should have broad bipartisan support, whether you're Democrat, Republican, Green Party, Red Party, or whatever party you're a member of.
Ms. Stripling?
I'd like to say that I think the conversation really that most of us want to have is not so much on taxes per se, but on the idea of building community and public service. And libraries really are a public service agency. And when you look at the return on investment, what you find through research is that for every dollar invested, there's $4 to $6 that comes back economically to a community. That there are thousands of small businesses that are being developed because of the services, tools, and technology that are available in libraries. And I think if you ask community members, they trust the public library, they participate, they vote with their feet and with their hearts, and that really the conversation needs to be about who we want to be as a community and how the library helps us be that community. More than just about taxes and laws. We need to get to the real substance of the issue.
All right. We were going to designate the last 15 minutes for questions from the audience. I'm not very good at estimating how long it would take to answer questions, but we got about this many. So I think it'd be all right if we start to go to questions from the audience. And once again, for those of you who have your name on the card, I will say your name, and if you would stand so that we could see who you are, raise your hand so that we can see who you are. This question is from Mr. Ray Bridewell. Ms. Bridewell? Oh, you stepped out. All right, this is Mr. Bridewell's question. If the issue is not about whether or not libraries are bad or good, why does the Tea Party want to abolish them? I don't know who would be the appropriate person to speak to that, but...
I can't accept the premise of the question because it's a question that's implying guilt right from the very beginning. Kind of like the question, do you still beat your wife? It's implying guilt right off the bat, and that's not the case here. By questioning the right method of tax rate doesn't mean that anybody wants to stop or hurt or kill the library. It's a matter of accountability.
All right. The next question, if you know, what was the legislative intent in modifying KRS 173 in 1984? Mr. Mando, Mr. Voelker, or maybe even you would know what the intent was in modifying it in 1984.
Well, I'll take a shot at it.
Okay.
I think, honestly, and I'm not positive, I'm speculating, but it's a healthy speculation. I think that the General Assembly recognized exactly what I was alluding to before, which is there is a lot of confusion as to taxing authority and how it is derived and how these districts that are controversial should be created and funded, and how their tax structures should be governed, their boards. And I believe in 1984, they made some comprehensive changes that affected the way you create these districts to bring the local governments more into control. Not sure where I was going with my analysis, but
it seems to me as if you were saying they recognize there may have been an issue with the mechanism for funding these tax districts, and certain ones needed to be spelled out differently, or whatever the case may be. You think that was their intent, but I don't know if they spelled it out in the legislation or not. With that in mind, though, they recognized in 1984 there was confusion about the tax districts and how many there were. Any insight? Does anybody have any insight as to whether the legislature hadn't tried to tackle either simplifying, modifying, consolidating the rules? Has anybody seen any courage on the part of the legislature?
House Bill 1 during this session, I think maybe took some beginning steps toward shining the light of transparency on the special taxing districts. When the state auditor began that project, they didn't even really know how many of these districts there were. Frankfurt didn't know. So there might be a question here, and if they didn't know, certainly I don't think most citizens or voters or taxpayers who are busy taking care of their families and going to work, they probably hadn't paid much attention to this. So I think here it is a question about whether elected or unelected people are making tax decisions because of the accountability factor. And I would just say that if the library board wants the power to tax, then let's make that an elected position. That would be another option. Another option, too, is there's enough passion for libraries here tonight that there could be, I think, lots of private funding raised to expand libraries, to build a new library, to provide the best library system in the entire state. I think that's an option on top of all the tax options.
I think most libraries do incorporate some volunteerism.
It'd be nice to hear more about that. It'd be nice to hear more about the philanthropic, the giving, because people give the causes they believe in.
If you ask the senator from my district, Senator Thayer, I believe he would tell you that he considered House Bill 1 to be step 1 of 2 and maybe even 3 of a multi-part reform. The first being the accountability and transparency, and the second being the substantive reform. I don't know what the temperature is of the entire General Assembly, but I know that it's discussed on a daily basis in the committee hearing.
It's hard nut to crack, right?
It is.
All right. Our next question comes from Mr. Ken Molden, Senior. Ken. Mr. Molden asks, is the library board willing to give its taxing authority to the fiscal court? And if not, why not? I guess that would be for you, Mr. Mando.
I hear that question one more time. Please, John. I feel like citing Eric's premise before.
Is the library board willing to give its taxing authority to the fiscal court? And if no, then why not?
Well, the General Assembly has set forth the process for the library boards, like other taxing districts, to set the tax rates for what they believe is appropriate in the circumstances. They use the compensating rate. If the General Assembly says that's the way you should do it, I'm not even sure they have the authority to cede that authority, even if they should choose to do so. Fiscal court's got enough on their plate. I mean, the fiscal court is charged with setting broad policy throughout the county. The reason I think you have some of these special districts, these other entities, is to try and manage those things so that there's oversight over those particular things. And so that would be my answer.
Okay. The next question is from Kathy Donnermeyer. Kathy? Is Kathy in the room? Oh, Kathy Donnermeyer. Why can't we simply begin where we are and legislatively change the funding procedure if that is needed? It seems to cut the current funding is very damaging to the existing library programs and services. Who do you think would be best equipped? Erik.
Well,
I'm saying Erik.
I'm not sure why, because I'm probably the only person up here that doesn't have letters behind my name. So I would really defer to somebody else who understands that better.
Yeah.
If I was a betting man, I would bet that the legislature right now is thinking grandfather type issues. And the question was, why can't we just start, regardless of the outcome? The way I'm interpreting the question is, regardless of the outcome of this case, why can't we just accept that the current model, that mistakes were made or not made, and move forward from here? And I can't imagine the legislature is not thinking grandfather, very thoroughly.
Is there anybody on the panel who would have a problem with grandfather?
I don't know. I might be definitely in the minority here, but I think it should be hard to raise taxes. Whether you're talking about the legislature doing it, the elected officials doing it, I think it should be difficult to do that. And that way, when it does happen, then it's truly been the voice of the people that have spoken, and it's something they want.
Yeah, I'm not sure that Ms. Donnemeyer, you can tell me if I'm wrong, if she's talking about asking for additional money, but I think she's saying just freeze it where it is right now, and then just...
Well, but the law, I think the law has to be followed. We're a nation of laws, and as passionately as I think a lot of people feel about this, that's not what determines the process. Like Mr. Mando said, the legislature not only determined that we would have library boards, but they also determined the process by which taxes would be increased. So you can't say we're going to follow the legislature on one hand, but when we don't like what they've done, we're going to try to do something different, or when it's harder. I think you have to be consistent, and I'm all for trying to change that. I think that a lot of local elected officials would rather not have to make these decisions. I think this is more about possibly locally elected, fiscal courts. We've seen this on other issues, where they would much rather have somebody else make those tough choices, and then when they see the citizens in the grocery store and the church on Sunday, it won't be quite as much tension there. But the law needs to be followed, and we need to have a way to hold our elected officials accountable for these decisions in our view.
All right, the next one is from Mr. Kim Ullman Jr. That would be him, Kim Ullman Jr. Here's his question. Should government entities grow faster than the community they serve? This point was made a little bit earlier, too. Based on the result of the election in 2012, the citizens of Campbell County seem to have said no.
I don't think there's any seam to it. They voted it down, and so the South Branch did not get built. The library board followed the statute, put it to the citizens. They voted, and the board has, complied with that decision. I don't think, though, to the extent that the question suggests that the library is providing services and doing more from what, providing more and having a lot of bells and whistles that the citizens don't need, I don't think that's the case. I think that the libraries in Campbell County, particularly in Kent County, are doing anything but. I mean, they're addressing and filling holes in our school system because of the lack of funding that we've incurred since over time by helping with literacy, making sure kids are ready to learn and assisting with their ability to read, helping people do online job applications when they don't, because they're out of a job, they don't have a computer, and they have access to the internet. Now, those types of things are very valuable resources to a community, very valuable to trying to help people of Campbell County. Allowing the rooms to be available for folks who choose to homeschool their children, providing resources to them. All those things are there and being used regularly on a daily basis across northern Kentucky, across the state. So I don't think that there's a situation where we've got all these things and they're not being used.
But are we going to say that because the voters voted down tax increase that they don't consider the libraries valuable? I don't necessarily agree with that. I think maybe they're saying we consider them valuable, but just like everything else that's valuable, there has to be a limit on that.
If I could add one comment, John, it's me, Kim, would be that I think the critical point that may be missed in this is that we're not talking about adding taxes at this point, but the terrible ramifications if this is upheld and the library does indeed lose 50 to 60% of its annual operating revenues. While you may not have seen cuts yet, I can guarantee you will see a significantly different library system if that funding is not replaced or lost in this way. Having looked just at my own library of what would happen with a 30% reduction, I can guarantee you, you will not have the same level of services, the same kinds of services available if the funding is not there.
And I think if the citizens don't like that, when that happens, then there will be a way found, I'm confident, in communities to make up the difference.
The two of you are prescient because you answered the next question that I was going to ask, and that is if the judge's decision is upheld, a 50% cut in funding has been reported. Is that correct? And how will this affect the library services? And there you have it, two different people's opinions on what will happen there.
Sure,
yeah, go ahead.
And if that is the case, there's also a fix from the library side, and that is getting the petition signed. They can establish the rate that's required, and it goes right back to the people that are using the library and the people that are paying for the library to help establish that rate.
Now, we were talking about HB 44 before, whether that's the valid way to fund the library. And one of the flaws of HB 44 is that it doesn't really apply to the library system, because the library system has board members that aren't elected. They are appointed within. And what HB 44 does is it closes the door to the involvement from the citizens, from the people, whereas KRS 173790 requires the petitions. So now the people are involved with establishing the tax rate. And now you have a community that is establishing the tax rate, and a board that is using that tax rate, and them by using that tax rate, they can establish the level of services and the size of the library. It works much better when the people are involved.
I think a major hurdle that you face is that there are many other, as many as 22, 24 other districts that do fall under House Bill 44 that provide similar types of services. And, to sort of change that just for libraries and not to change it for fire districts and for health districts would be a tough sell.
Aaron Sutherland. Aaron? Right here. Aaron has a question for you, Mr. Waters. How would you suggest libraries determine which materials to provide to the general public? Are some materials / resources more important than others? Who makes those decisions? Politicians?
This goes along with something I was going to add to what Erik was saying. My understanding is that candidates for library boards, they originate out of Frankfurt. And I think that ought to change. I think the candidates for that ought to come from the local community. And I think, but the final decisions are made here. But the candidates have, the library, the state library, I got that, the state, how is the library board here appointed?
Jim, I think what happens is three people from the county apply.
Chosen
they
by
submit their names to KDLA.
But why
the commissioner sends 3 names to the judge executive.
But why do we need, my point is, why do we need that? Why can't the local citizens choose their own people without Frankfurt's involved? They don't need that. So then when that happens, then I think what services are important are then determined by those people and by the local people. And it may be different. It may be different here. The needs of this community might be different than they are in Western Kentucky or Central Kentucky. They might be different. So that's why we need to have as much local. That's what my point is, that we need to have as much local say over that. And so I don't think anybody should sit here and say what's more important than other. When I mentioned the videos, I was just using that as an example of maybe you have to redistribute some monies to something that may be more important. Everything's important now, but there might be something that might be more critical, and so you should be open to that.
I think this next question is directed to you, Erik, and that is, what excessive action caused you to begin examining the method of funding?
Well, there was a series of events that happened, and I've talked about this before. It started with the talk or of establishing a new library in the south part of the county, and there were hearings that were held in various parts of the county about the new branch, and I attended several of those meetings. And I posed, at every meeting that I went to, I posed the same question. And first of all, if you go to this report, very lengthy, if you like charts, this is a great one. It's the Statistical Report of Kentucky Public Libraries. And it's updated annually. Now, if you go by that report, you can compare your library system to the other systems in the state. And one thing that stands out is that when you compare the Campbell County system to the statewide system, there is actually more library space per person in Campbell County than there is in the state average, which tells me we already have enough buildings. We already have enough square footage. We don't need to be adding more. So the question I posed at those hearings was, well, I'm sure this map is really hard to see. This is Campbell County, and we've got the 3 libraries all right here. There's nothing down here. So to me, the logical answer is we've got the buildings, we've got enough space. They're just distributed wrong. Why don't we move one of the branches down to the south branch? Because I don't want to deny anyone in the southern part of the county a library system or a library that's accessible. And I got the same answer every time I posed that question, and that was, we're not going to close an existing library branch. And actually what I was really posing was, not really, we're moving. We want to move it down to the southern branch. But that was basically taken off the table. And so I even sent a letter to the library board after those hearings, and showing charts and numbers and showing how we can go ahead and build that branch down there, even though it costs $5 million to build that new branch. Let's go ahead and do that, but move the operation of one of the existing facilities down to that south branch. And by doing that, we would save, over a course of 20 years, we would save about $19 million. And that $19 million is coming from us, the people in the county. So basically, everything's solved. But I received a letter back very promptly, dated December 1st of 2011, that said, thanks for your input, but we are not closing any libraries. So, at this point, I'm very frustrated. So I attended the meeting at December 2011 at the library board, and I brought to the board's attention part of the KRS that says that they can only borrow 50% of what their annual income is. And I was told that bill really doesn't apply in this case because there is a loophole that the library uses to go around that. But at that same meeting, that's when, in fact, I hadn't talked to Brandon before that, but that's when Brandon brought forth the issue of KRS 173790. And even after that meeting, when the library's board determined that KRS 173790 didn't apply, I walked out of that meeting really frustrated, and because I felt like they just don't want to listen to us. So I didn't know what to do at that point, and I didn't want to be a part of a lawsuit against the library. And so I took the matter to fiscal court because the judge executive in fiscal court actually has a part of the choosing the library board members. So I posted it to them, made copies, showed it to them, and I got kind of slapped down the same way that I did at the library board meeting, that basically, we're not going to listen to you. And that's what, at that point, that's when I contacted Brandon and said, I'm not being listened to here. The only thing we can do is get a judge's decision. So that's when I let Brandon know I was interested in being a member, or a plaintiff in that lawsuit.
We've come kind of full circle, and we are right at 7 o'clock, which is our quitting time. But before we go, I have one more question that I would like to pose for you to vote on, all right? And this is not the end of the discussion, by the way. I'll explain in a second, but why are you most interested in this topic? A, I have concerns about my local and state government's budgets. B, I am concerned that my local library will decrease services. C, I have concerns about all of the community having access to technology, educational resources, and affordable entertainment, such as books, music, and movies. Or D, others, if you can vote now.
And just so everyone knows, we don't have clickers, they're not letting us vote.
I got one, right?
And I've been voted 22 times.
All right, and here we have it. B and C are tied at 34% each. I'm concerned that my local library will increase services. I have concerns about all of the community having access to technology, educational resources, and affordable entertainment. 23%, I have concerns about my local and state government's budgets, and others, 9%. We are going to continue this conversation on the Facebook page. Everybody who knows how to mess with Facebook, I got 5,000 Facebook friends. I know some of you guys are on Facebook. Seriously, we're going to continue this on Facebook. It's something I'm pretty sure that you can gain access to. And Tara, what is the official page name? Because I know sometimes that can be confusing.
Well, it's Northern Kentucky Forum, but Northern is spelled out, Kentucky is spelled out, Forum.
It's not NKY Forum, it's
Right.
Northern Kentucky Forum. Look that up on Facebook, and I think that they are going to post some of the questions, actually. And you can engage from there, and I hope in the same civilized way that you did here tonight. Let me thank our panelists. We have Mr. Brandon Voelker, we have Erik Hermes, we have Mr. Jim Waters, we have Mr. Andrew Hartley, Ms. Barbara Stripling, Ms. Kim Fender, and Mr. Jim Mando. We give them a big Okay, here's our upcoming public forum. Be there and be square. Healthcare reform. Oh, I don't know if we can keep that one civil. Healthcare reform. How will it work for you? That's next Wednesday, September 18th, 6 to 7:30 p.m. at the Center for Great Neighborhoods.
You're gonna moderate that.
Center for Great Neighborhoods. It's on Russell Street in Covington. Absolutely.
I don't want that. What is it?